Senator Norris.
Thank you very much, Ciarán. I have to say, listening to Senator Cassidy, it's the most impassioned speech I've heard him make in the Senate for some time, and made me wonder if I was actually on the right side, because I don't always agree with him. But I have to say, I've been approached by various interests in this, and I do think it's kind of a balancing act, it's a balance of rights, because there's a whole generation of young people who feel, whether rightly or wrongly, or with legal support or not, that they have developed an entitlement to free downloading, and that is embedded in our culture. Now, there is going to be a public relations difficulty in selling whatever agreement is reached. I think one must be aware of the interests of young people. So that is what I would say is the establishment of apparent rights on the ground. The fact is, and the facts are quite stark, that an enormous number of people, the vast majority of young people, are engaged in this practice. 675,000 in the space of a year. That is an enormous number of people. So I think this matter has to be addressed without alienating an entire section of our community. But on the other hand, the arguments that have been made here are extremely good, in my opinion. And I've been told by somebody who's directly involved in it that, for example, U2, their first album bombed. And without the support of the record industry, they would not be in the position they're in now. And if that first record has just been downloaded and deleted, the commercial interests might have said, well, we're not interested in this anymore, we're going to wash our hands of it. And I think there are a number of situations like that. There's also the situation that a number of artists make their work available freely through the internet. I mean, I think particularly of George Michael, who made a clear statement on this, and I think also Sinead O'Connor. However, our business is to function as a legislature. We're charged with putting laws in place. And in doing this, we often get the advice of the courts. And in this case, there are a series of legal situations that have emerged in which a very, very clear series of judgments have been given, in particular the judgment of Mr. Peter Charlton. And I will be referring to that from time to time. Now, I'm very grateful to the Minister, first of all, for giving me a copy of his additional remarks. In fact, it was a little bit more expansive than even this provides us with. But it is interesting because this is the one that this is the section of his speech that actually addresses the issue which prompted Senator Cassidy and others to put down this opportunity on the order paper for us to engage in statements. And I was a little bit surprised that it's only dealt with in this short introductory section of the speech. The problem is, in my opinion, that although the Minister says that the material was, the European directive was transposed into Irish law, and he gives the regulations under which it was transposed, he indicates himself that where an internet provider establishes that it is a mere conduit or carrier of information, they are not liable. Regulation 17 similarly covers caching or temporary storage. Regulation 18 deals similarly with hosting or permanent storage. That is precisely the difficulty that Mr. Justice Charlton addressed. And the Minister goes on to say, however, these regulations do not affect the power of any court to make an order against an internet service provider requiring the provider not to infringe or cease to infringe any legal rights. But there's nothing about the responsibility of the provider in terms where he is clearly, this entity is clearly and knowingly facilitating what Mr. Justice Charlton has described in his judgment as theft and piracy. Now, what has been recommended is graduated response. And there's a whole history of negotiation between the music industry and its representatives and the internet service providers, and I'll go into that in a minute. But in looking for a graduated response, I should point out this is already in operation in France. It's agreed in the Digital Economy Act in the United Kingdom. Finland and New Zealand have already agreed to pursue this route as well. And Korea has had graduated response in operation for quite some considerable time. Now, the reason I say that we have to have some response, we can't leave a lacuna, is because in his judgment, Mr. Justice Charlton has identified the problem, and he has clearly put it on the record of the court in a written judgment that Irish law is deficient. The second point is that he has indicated that the solution lies in the graduated response approach to which I've just referred. But he is not in a position to enforce this or to give injunctive relief because the European directive was apparently inefficiently and inadequately transposed into Irish law. The third point is that Irish law can be brought into alignment with the intention of the European instrument with a simple statutory instrument. As long as Irish law is deficient, Mr. Justice Charlton, I'll put the figures on the record, found that all creative Irish industries are losing money. And finally, this is creating a black hole which may lead to yet another situation where, although they were not implicated, the taxpayer is left picking up the bill. And I don't think the general public want that. Because of a legislative deficiency, the music industry companies are able to take legal action which will land the Irish taxpayer with the bill. That, I think, will be worrying to everybody, particularly in these very difficult economic circumstances. Mr. Charlton indicated that legislative intervention is required if the Oireachtas sees fit to protect constitutional rights to copyright and foster the national resource of creativity. Now, one of the problems is in the wording of the regulations that the Minister referred to, because he did not use the words that appear to be required, and that is making provision for blocking, diverting and interrupting internet copyright theft. And because of that lack, because of those three words, we are technically in breach of the European directive. Now, this comes about because of developments in the technology of recorded music performance and access to it by the public. In particular, there's a lot of new developments that are a bit beyond me, the kind of peer-to-peer sharing through iPods. From somebody of my generation, I cannot understand why anybody would want several thousand tunes. But then I'm not a kind of glutton culturally. I mean, if I visit the Louvre, for example, I make sure that I do not overindulge and give myself aesthetic indigestion. I head for those one or two rooms where I can enjoy in a profound way the works of art that are there, but I see tourists going through and they do every room in the place. I don't know how their brains don't explode. They must be insensitive to the arts. However, it's very good for tourism. On a similar basis, I am glad that I'm not of the iPod generation, because I would never willingly sacrifice the thrill and the delight of the chase and the hunt of anybody who's a specialist in musical collections. I mean, I was exhilarated for a week when I found an ancient record of the original Dixieland jazz band in Fenning's record shop on the Quays. I used to scour them, go through all the boxes, and that joy of finding something, and that immense joy of listening to your treasure trove when you get it back home. If you can just push a switch and you get 1,500 tunes straight away from your neighbour, I mean, I think an awful lot of the joy is gone, but one cannot hold back technological advances. I just want to say what Mr. Justice Charlton found, because these are the facts that are established. And I do understand the feelings of young people who feel this entitlement, and I think that's got to be addressed and dealt with. But the situation on the ground, the facts as established by the judge are, and I'm quoting from his judgment of the 11th of October, just a few weeks ago. Between 2005 and 2009, the recording companies experienced a reduction of 40% in the Irish market for the legal sale of recorded music. That's a devastating blow. I mean, I don't know how many industries could tolerate a decline, a sudden and spectacular decline of 40% of their market. 670,000, 5,000 people in 1 year. using this process. Now, does that mean that we have 675,000 criminals? I don't think so. We have 675,000 people who are infringing copyright law. He continues to say that those 20 million sales lost annually, that's a big hole in the budget of the music industry. And goes on to say, in a very stringent comment, I am satisfied that the business of the recording companies is being devastated by internet piracy. This not only undermines their business, but ruins the ability of a generation of creative people in Ireland and elsewhere to establish a viable living. It is destructive of an important native industry. Well, the reason that I contacted people in the industry and spoke to Senator Cassidy was because I was particularly concerned by an article by Niall Stokes, an editorial in Hot Press. Now, this is a magazine that goes to a lot of young people, and I thought it was an example of courage that he addressed this situation so openly, because I doubt if it was all that popular with his readers. But when I saw somebody who was passionately concerned with the music industry, and not, I think, linked to the profits, because I know people say, oh, to hell with you too, they make all these millions and they use their tax haven in Amsterdam or wherever it is, I don't know. Not much sympathy for them, but I think Niall Stokes, when he comes in and speaks, he has to be listened to. Now, again, he said that the directive was to ensure that injunctive relief should be available in national law despite an exemption applying. And he went on to say, in failing to provide legislative provision for blocking, diverting and interrupting internet copyright theft, Ireland is not yet fully in compliance with its obligations under European law, and the courts cannot move to provide injunctive relief. Now, what was the effect of that? There's an irony here. I'm told that the effect of the publicity surrounding this judgment was to multiply theft. And there's been an increase of over 30% in these kind of downloads since, because people in the public were given the impression that this was perfectly legal and they could go off and do it. At the moment, 60% of Irish internet suppliers are either actively supporting or prepared to support the music industry. That leaves 40%, and discussions have been going on, and they can be looked at in a chronological form. The IRMA wrote to all the internet providers to try to bring them on board, but they found it was impossible to get a date that suited everybody. They couldn't agree the agenda, so although they didn't actually refuse, they didn't come along. They had their own interests. And then there was a Belgian case which introduced a new technology, audible magic, for filtering illegal material from the network. And based on the history of what had happened and the discussions with the internet providers, plus this new technology, IRMA went to court against Eircom. That was heard in January 2009, but settlement was reached whereby it was agreed that the music industry, IRMA, would find evidence of peer infringement, provide that to the service Eircom, and they would engage in the three-step graduated response. And Irma agreed they would negotiate with other service providers to get them to operate the same system. And various documentation was exchanged. They were unsuccessful in getting either British Telecom or UPC to cooperate in that, so there was another case. But before that got to court, the Data Commissioner intervened, and there was a suggestion that could be that there could be some infringement of provisions concerning privacy and access to data and so on and so forth. That led to another court case in which the judgment, which was given again by Judge Charlton, who seems to be something of an expert in this area, was given on the 16th of April 2009, and that confirmed that none of the Data Protection Commissioner's concerns were valid, and that the graduated response as operated by Eircom and Irma complied with data,
Sir, you have 1 minute left.
with data protection legislation. So the way was then clear.